Good morning. My name is Bianca Simmons, the North Carolina Bar Foundation Pro Bono Programs Coordinator. Today we have with us Trevor Smith, who will be presenting Intellectual Property Protection, a comprehensive overview. Trevor has extensive experience in matters associated with intellectual property prosecution, licensing, enforcement, and strategic counseling. He effectively works with companies to monetize and protect their IP through licensing, development, reseller agreements, and associated contracts. Having managed domestic and international trademark portfolios for Fortune 500 companies, he has considerable experience in all stages of the life of a trademark, such as selection and clearance, application preparation, prosecution before the United States Patent and Trademark Office, foreign filings, opposition and cancellation matters, preparing and responding to cease and desist letters, domain name registration, and protection strategies in UDRP complaints. As you see, Trevor knows and has done it all. Trevor is also a registered patent attorney with a technical background in physics. He has drafted and prosecuted a number of mechanical, business method, and software related patent applications. I will now pass it over to Trevor. Enjoy the presentation.
Four different distinct buckets. And there's always some overlap between the types of intellectual property. So you may have one thing that's covered by both patent and copyright. For example, software is something that could be protected by both copyright and patent. But it's key to understand the differences between the different types of IP, what they're trying to protect, and how you go about protecting your interests in those. And so those four main categories are patents, copyrights, trademarks, and trade secrets. And we'll touch on each of those briefly. But I also think it's important to just at a high level understand one important concept for IP. And I get this question a lot. People will come to me and be like, I've got this idea for this business. How do I protect my idea? And the reality is you can't. Ideas are not something that are protectable within intellectual property unless it fits into one of the four buckets that we've talked about. So unless you can take your idea and formulate it into an invention, or take your idea and protect it by copyright, or take your idea and identify how people find that idea from you through trademark, you're not going to protect the idea itself. And so that's always important to keep in mind. So the first broad category of intellectual property that we're going to talk about are patents. Now, patents are really inventions. So the way to think about it in your mind is it's going to be a process, a machine, a method of manufacture, potentially a composition of matter. And in order for it to be subject to protection by patent, it has to be new, it has to be useful, and it has to be non-obvious. Now, we all have understanding of what new and non-obvious means in our minds, but those have very particular meanings within the realm of patent law. So when we say that an invention has to be new in order to be eligible for patent protection, what that means is that it's not fully described within either an existing U.S. patent or patent application or within any sort of available publication. So if I file a patent application and the patent examiner can pull up an existing patent application that describes the same thing, it's not new. So it's not going to be eligible for patent protection. The useful category is pretty easy and a pretty low bar to stand. As long as it's accomplishing something that's practically useful, it's going to be eligible for patent protection. So that's not usually a bar that I see being an issue for most people. The last one is kind of non-obvious. And that, I think, is the one that it's a little bit harder to kind of distinguish between what we typically mean when we say it in English, non-obvious, versus what it means for patents. So for non-obviousness for patent protection, what we're really talking about is there an existing patent that if I combine it with another existing patent, that those two patents combined together would fully describe what I'm trying to claim within my patent? And if so, it's considered to be non-obvious if somebody who's working in this field is skilled in the art would think to combine those two patent applications. So you can't really take steps A and B from patent one and steps C and D from patent two and combine those together and get separate protection. That's something that's going to be rejected for being non-obvious. So you come together and you have something an invention that you think is new, useful, and non-obvious. But there are certain categories of information that's really considered to be not patentable. And those are laws of nature, physical phenomena, and abstract ideas. For example, nobody's going to get a patent on gravity. It's just out there already. It's a law of nature. It's not something that can be protected. But if you find a way to take gravity and turn it into a useful machine, that may be something that's patentable. So as you're working with a patent attorney or as you're thinking about your invention, one of the things you need to look at is, am I doing something that's beyond a law of nature or beyond an abstract idea? Have I taken something that's more practical and something that's going to be eligible for protection? This idea of abstract ideas becomes particularly important for a class of patents that I'm commonly asked about, and that's the idea of a software patent. So many people come and want to protect, their software through patent protection. And it's possible to do, but there are some limitations to what software is protectable by patent. So there was a Supreme Court decision in June of 2014 that really narrowed the scope of patent protection that was available for software. They didn't say that no software was eligible for patent protection, but it really limited it down to what was considered to be patent eligible. And the way the court talked about it is it has to do something more than merely implement an abstract idea. So, for example, you can't take a piece of software that could run on any computer and that just executes pretty standard steps and secure patent protection for that. So, for example, if you were trying to protect a patent that collects, information about historical trades for the stock market, and then you took that information, you processed that information, and then you executed trades based off of that. That's the type of, basic implementation of, an abstract idea that's not going to be eligible for patent protection. So if you're looking to protect your software through patent protection, you really need to identify something more than that. So typically what we're seeing now is as eligible for patent protection software is, is the software changing something in the physical world? Is the software improving the processes of the machine that it's running on? Is it, improving other technology? Can you connect that software with other pieces of equipment to accomplish your goal? And that may then ultimately be protectable by patent. So I think for our purposes today, the way I would think about it is know that there is some protection for software, but if what you're doing is really something that can be run on any general purpose computer that is just executing a few, simple steps in your program, even if it's something unique, it may be something that will be challenging to protect through patent law. So then how do you go about protecting your patent? If you do have an invention that is patent eligible, how do you go about protecting it? Well, in the United States, we are now a first to file country. So that means that your rights in the patent come about through filing an application to register the patent. So it's important that once you've identified something that is protectable, that you go ahead and try to protect it, because without seeking your patent protection, you're not going to have the ability to exclude others from practicing the patent unless it kind of falls into one of these other areas of IP protection. Related to kind of filing and protecting the patent, something that's important to keep in mind is who owns the patent. And in the United States, patents are generally initially owned by the inventor of the patent. And so inventorship is defined as somebody who has contributed to the conception or reduction to practice of one of the claims within the patent. So that can be multiple people, it can be one person, it could be people who weren't even necessarily working together. But when you draft your patent application, the patent application is going to consist of a number of parts, but one of them is going to be kind of your pictures of the invention. It's going to have a broader specification that describes everything about it. But then you get to the end of the patent application and you're going to have what are called your claims. Now, the claims in a patent really set forth the outer boundaries of the protection of the patent. And so when you look to the idea of inventorship, that's where you have to look. Has this person contributed to the conception of this claim? has this person contributed to the reduction of practice of this claim? And if so, they will need to be identified as an inventor with the patent and will initially be a full owner of that patent, even if they've only contributed to one claim. Now, if you're a business owner, that's important as well, because people, your inventors are going to own the patent at the outset. So you have to have agreements in place, either through employment agreements or invention disclosure agreements that require your employees, require your consultants to assign their inventions over to the business. So keep that in mind as a business owner, that you are not necessarily going to own the patents that have been created on your behalf, just again, because you either paid for it or funded it. You're going to have some agreements in place to transfer those over. So as it says on the slides, patent protection goes from 20 years from the earliest filing. So essentially the deal is you disclose to the patent office everything you know about the patent, everything that somebody else would need to know in order to kind of practice the patent. And in exchange for that, you get exclusive rights to the patented invention for 20 years. One other thing I want to touch on with regard to patents that's important for young businesses to think about is that there are certain things that you can do that will make it so that you're not ever able to secure your patent. And so there are what are called statutory bars for patent protection. So if you go out and start to sell your invention or sell products that embody your invention that's described in your patent, and you do that more than a year before you file your patent application, it's possible that you're going to be barred from ever securing patent protection. So the law essentially is trying to incentivize you to get your patent application on file as soon as possible. Now, this is always a balancing act for businesses, because patent applications are not an inexpensive endeavor. And so you always have to balance the timing of the filing versus the costs associated with it. And one of the ways that you can do that is through what's called a provisional patent application. So there's what's called a provisional patent application, which doesn't include all of the details and the specifics of a full utility application. But what it does is you disclose a certain amount of information in the provisional application and you get it filed, and it effectively holds your place in line for up to a year before you have to convert it to a full utility application. So this is an effective tool to help you kind of stretch out that period of time so you don't lose the possibility of securing patent protection due to an on-sale bar or disclosure within a certain publication. So as it says on the bottom of the slide, the way infringement comes about. So if you're thinking about how do I protect my business from being accused of infringing somebody else's patent, or how do I know if somebody else is infringing my patent? Really, what the patent provides is an exclusive right to make, use, sell, offer to sell, or import the patented invention. So if you're doing any of those steps and what you're doing includes every element within one of the patent claims, it's potentially an infringement. And so again, the scope of the patent is going to be solely determined by the patent claims. So you're going to have to really get into the very end of that patent where the claims are and walk through the steps of each claim and say, am I doing step A? Am I doing step B? Am I doing step C and D? If you say yes to all of those, it's potential that you are infringing the patent that's described there. If you're doing 3 out of the 4, it's possible that you're not infringing that patent. So that's where you have to take a close look to see if there's any infringement involved. So another big category of IP protection that's out there is copyrights. So copyrights are a bit different than patents in that they're not seeking to protect inventions. What copyrights protect are creative and original works of authorship. So this is a pretty broad set of categories because it can cover everything from, a painting to a book, to a play, to a musical composition, all the way out to software and certain databases that are eligible for protection for copyright. So, as you think about your business and what you're doing, websites often have lots of copyrighted information that it's protected there. Photos that you take for your business, photos that are taken on behalf of your business, the software that you create and then trying to sell, all of that is something that's going to be protected by copyright. Similarly, it's important to remember kind of where the boundaries of copyright protection lie. So what can't be protected by copyright? Again, a broad-based idea that you can't protect an idea by copyright. It still comes into play, but you can't copyright facts on their own. So, my address on its own is not something that's eligible for copyright protection because that's a fact. Who fought the Battle of Waterloo is a fact and is not something that is, can be protected exclusively to one person. But if you write an entire history article or an entire book on those facts and present them in a unique way, that is something that would be eligible for copyright protection. Similarly, titles, names, short phrases, those are things that are not typically protected by copyright, but may fall within the realm of trademark protection. So it's important to keep in mind that there may be many different types of copyrights in a single work. And some of the easiest ways to think about this would be, like a musical recording. So if you're sitting at home and you're streaming your favorite, song of the moment, there's probably 3 or 4 different types of copyright that are embodied within that song. You'll have the lyrics, you'll have the musical composition, you'll have the overall composition, and all of that is going to be protected individually and in a combined form by copyright. So again, it's important to keep in mind for copyrights how ownership is initially created. And this is somewhere where I see a lot of small businesses get initially tripped up, is that for copyrights, ownership is initially vested with whoever created the work. There are a few exceptions to that rule, which are important for businesses, but keep in mind that the initial creator is going to own that work unless it falls within one of these exceptions or unless there's a including the contractual obligation to transfer. So the exceptions to ownership of a copyright are what's known as a work for hire, and then employment, things that are created within the scope of somebody's employment, and then a contractual obligation to transfer those copyrights. But it's important to keep in mind that those exceptions are fairly limited. I often hear people say, well, I paid this person to create my website, or I paid this person to create my media content, and therefore it's a work for hire and I own it. That's just not the case. So it's important to keep in mind that when you are working with independent contractors or other businesses to create creative works on behalf of your business, you need to have contracts in place that specify that what they are doing is for the benefit of your company and that they're transferring their rights and that copyright to your business. Otherwise, you can get into a situation where you as the business owner think that you own the copyright. It's of important value to the company, but ultimately somebody else owns it. And when you come in to either sell the company, take on a future investment, this can create a number of headaches for the company. So I always encourage you that if you're hiring somebody else to do work for you, even if it's a friend or a neighbor that has offered to put together some creative works for you, have something in place saying that they're transferring ownership to the business. So your interest in the copyright arises almost immediately. So upon creation and publication, you have rights in that copyright. So you have that exclusive right to what you've created and other people can't do it. But you gain kind of additional benefits by seeking registration in that copyright. So specifically, if you seek to register your copyright, it's going to provide you potentially with access to statutory damages and the right to sue for copyright infringement in federal court. So without a registration, those are not things that you're going to be able to pursue, and you're just going to have to rely on kind of your rights in a copyright. So again, it's going to be a balancing act for the business to decide what is really important for us to protect, what is crucial to kind of consider that would be really damaging to the company if somebody else started to use and that we would need to be able to stop them from using, and versus the kind of the cost for applying for the copyright. Because compared to patent applications, copyright applications are relatively inexpensive with regard to their filing fees, but at the same time, copyright protection is fairly narrow. It's really only covering the specific work that you're describing within the copyright application. So, if today I publish a website and it looks the way it does on July 13th, that is a specific copyright. But as I kind of make changes to it, as it progresses over the weeks and months, in August 13th, it may look completely different. And at that point in time, it would be a separate copyright. So I'd have to decide, Am I going to file multiple applications as things change, or can I file just one copyright application and get good protection for what I prepared in the past? So that's something to consider for businesses. So the term for a copyright is pretty long. Typically, it's considered the life of the author plus 70 years, or if it is a work for hire, 95 years from publication or 120 years from the day of creation. So, again, once you get that protection for the copyright, once you've created it, it's something that's typically going to last for an extended period of time for your business or for yourself. So infringement comes about when somebody is practicing one of the exclusive rights in the copyright. And those exclusive rights are the right to reproduce, to sell, to create derivative works from, or to perform publicly. So, if you have, say, created a brochure that describes a process from your business, and somebody takes that and starts handing it out or emailing it to their listserv verbatim, exactly what you had written, that's a copyright infringement because they're reproducing the work that you created. And it's substantially similar to what you created because, again, it's identical. And that's something that's going to be a copyright infringement. But the idea of a derivative work is something that is important and I think often misunderstood as well, is you can't just take somebody else's existing copyright and make changes to it and claim it as your own. There are certain things that you can do to it that have changed it enough that it's something that you can claim protection to. But you don't necessarily have the right to take somebody else's work and start to create your own work from that, because that's considered a derivative work and could be a violation of their existing rights in the copyright. So the next big bucket of kind of IP protection is trademark. Now, the trademarks are anything that distinguishes your business from somebody else's business and can be used by consumers to identify your business and distinguish your goods and services from somebody else. So that could be words, it could be specific symbols or designs, logos, it could be the specific shape or configuration of your product packaging. It could be even something as unique as colors or smells or sounds. Anything that when a consumer encounters it, they're going to be able to rely on that to identify your business or your products and services. That is going to be something that functions as a trademark. I guess we're going to slide in and fly in here some of the examples. But again, so these are some of the symbols and designs that are eligible for protection. But even the product packaging itself. So if you think of the distinctive shape of the Coke bottle, that is something that they have secured protection for as a trademark. The shape of the bag of chips for Sun Chips, for example, can be product packaging that is eligible for protection. Now, it's important to keep in mind the difference between a trademark and your trade name. So many people, go to the Secretary of State, they form their business. So it's either an LLC or a corporation. They file the paperwork, they've got their name, new business, LLC. That's a trade name. That doesn't necessarily function as a trademark unless you start to take that same name and apply it to advertising, apply it to your goods and services, and use it in such a way that people start to distinguish it from the services of others. So an easy way to kind of think about this is the Bojangles trademark. So on the left here, you see the logo formation, Bojangles, famous chicken and biscuits. That's a trademark usage of Bojangles. That's showing a trademark that people can use to identify that business, know that they're going to go get biscuits that they're familiar with. That's a trademark. On the right is the entity name that's associated with Bojangles. It's Bojangles International, LLC, and that's a trade name. And the important thing about the trade name is you're not necessarily getting exclusive rights to that name if you're not using it in connection with your advertising or sales or in a way that makes it start to function as a trademark. So as you're thinking about trademarks for your business, it's important to kind of start thinking about it early on and make sure you're identifying something that is really going to be protectable. Because not all trademarks are created equal, as I say here. So there's essentially a range of protection that's available for different types of marks. On the strongest end of that range are what are considered arbitrary or fanciful marks. So an arbitrary mark is a word that's just completely made up, has no meaning, has no understanding, and therefore the only function that it serves is to identify your goods and services. A fanciful mark, actually I got those backwards. So yeah, fanciful mark is made up. Arbitrary is going to be one that has a specific meaning, but doesn't have any meaning in connection with your goods and services. The easiest one to think about is apple. So apple's a known term, it's a fruit that everybody knows, but when you apply it to personal electronics, it doesn't have any meaning except for as a well-known company at this point in time with a very valuable and protectable trademark. So that's the strongest type of mark available, one that really has no meaning except for to identify your goods and services. The next level down is what's considered a suggestive mark. A suggestive mark doesn't necessarily immediately describe the goods and services that you're providing, but implies some aspect of it. So say, for example, I was starting a new shoe company and I wanted to call the shoe company Hops. Well, Hops doesn't necessarily describe the shoes. It's suggesting that these shoes are something that are going to help me to jump higher or run faster or something along those lines. So it's not immediately describing those goods, but it's suggesting some aspect of what they are. So that's kind of that second level of protection. The suggestive mark, it's something that's immediately protectable and just a step down from arbitrary and fanciful marks. Then you fall into kind of the weakest category of trademarks. And this is always where lawyers and marketing teams kind of butt heads, because marketing teams typically want advertising or promotion to immediately convey to consumers what it is that you're doing. And that's fine. It's just not generally something that you can get exclusive protection to. So, for example, if we go back to this example of the Bojangles trademark, down here they have the tagline, famous chicken and biscuits. Chicken and biscuits immediately describes what it is that you're receiving from this business. And so if they tried to protect that as a trademark, really, they can't get exclusive protection for that mark initially, because it's immediately describing a function, feature, or characteristic of the goods that they're providing. So in the US, at least, you're not eligible for protection on the principal trademark register for a merely descriptive mark, unless you can show that you have used it for such an extended period of time that consumers no longer view it as just describing your goods and services, but they've actually in their heads come to associate those descriptive terms with your business and your business alone. So as you're thinking about your mark, ask yourself the question, does this word, does this term immediately describe the goods and services that I'm trying to protect? And if so, it's not something that you're likely to be able to get exclusive protection for. And then the very bottom category, the one that is never eligible for protection as a trademark, is the generic mark. So no one's going to get exclusive rights to the use of the term shoes for shoes or phones for phones. That is what they are. And you can't take those terms kind of out of the lexicon and prevent other people from using it. So after you've identified kind of a mark that you think is good and protectable, conveys your kind of brand idea, the next step is really important, and it's one that I think a lot of people overlook, is the mark available? So you have to go out and see if somebody already has an existing application for it. Is somebody else already using it? What are they using in connection with? And do an analysis that we'll talk about in the next few slides about whether or not this mark is available for my use. Then aside from the kind of just this question, is the mark available? Ask yourself, is it something that I can use effectively to reach my core audience? And that's really getting into things like, is the domain name available? Is the social media handle that I want to promote my business through, is that available? Are there a lot of similar marks that are going to crowd out my promotional materials so that people aren't going to be able to find me? These are all considerations that you need to keep in mind as you're picking a trademark. So now we get into the question of how do your trademark rights arise? And in the United States, at least, trademark rights arise on the basis of use. So if you go out and you start to advertise your business and promote your goods and services using a trademark, you automatically have rights in that mark. These rights are going to be limited to the geographic area in which you've used the mark, though. So initially, if, say, for example, I start opening a business in Durham, I have a kind of a local following, I put some advertising into circulars in neighborhoods around me, I'm going to have what's called common law trademark rights in that geographic area, and maybe kind of a reasonable zone of expansion around that. But if somebody in Washington State starts to use my same mark in connection with the same businesses, and I've never provided goods and services out there, I'm not going to be able to stop them from using my same mark unless I've filed a federal application to protect the mark. So know that your rights immediately begin to arise based on your use, but you have the ability to kind of expand the geographic scope of protection for your mark by filing an application. So there's a couple different types of applications that are available. Most states have a separate trademark registration option. So like in North Carolina, you can file a North Carolina state trademark registration. It's going to provide you with protection for the mark in the entire state of North Carolina, but it's not going to provide you protection kind of outside of the state. The more common option is for people to file a federal trademark application, and that's going to get you nationwide priority to your mark from the date that you file your application. So if you file an application on July 13th, it goes through the process and you ultimately get it registered. Your nationwide priority to that mark begins from July 13th, even if you haven't used your mark in a vast geographic area. So a trademark can potentially last in perpetuity, forever. As long as you continue to use the mark in connection with your goods and services, you can have protection for it forever. A federal trademark registration has a term of 10 years, but as long as you can continue to prove that you're using the mark and pay the applicable renewal fees, you can renew that trademark registration indefinitely. So, I mentioned the fact that one of the things that's important when you're considering a trademark is my mark available? And, I've had a lot of people come to me and say like, well, I typed in my mark into the trademark office's database. There's no one's using this exact mark, so we should be good to go. And that's a good sign that there's not an exact mark that's out there, but it's not necessarily sufficient. Because the standard for trademark infringement, and therefore what you have to think about when you're clearing a mark, is whether or not there's a likelihood of consumer confusion. So that is the ultimate test for trademark infringement. Will consumers believe that my mark and my goods are so similar to somebody else's mark and goods that they originate from the same source, or otherwise believe that they're affiliated or sponsored? And if that's the case, then there's the potential for an infringement claim. So the common factors that you need to think about when you're looking at it is, are the marks similar with regard to sight, sound, and meaning? And are the goods and services, the types of goods and services that typically originate from the same source? So it goes back to my earlier point. Going to the trademark office database and seeing if somebody has the exact mark isn't necessarily sufficient, because if they change one or two letters, but it's still pronounced the same, it still looks generally the same and would have the same meaning, and they're using it in connection with goods and services that are similar, then it's potential that there's a likelihood of confusion. Now, with regard to the similarity of goods and services, I think we can all typically understand this. You just put yourself in the role of a consumer. If I'm out there shopping and I see this trademark on this product, am I likely to believe that it has originated from the same brand that I know? So let's take, for example, like Dove skincare. They make a lot of different cosmetics. They make a lot of different skincare products. If I see Dove on shampoo, am I likely to believe that that's associated with that same Dove that I know prepares the lotion that I have in my house? Probably. Shampoo and lotion are very similar types of product. If I see Dove used on an alternator for my car, am I likely to believe that that originates from the same company that's making my hand lotion? No. The goods and services are so different that it's unlikely that they originate from the same source. So it's important to keep in mind that it's possible that somebody has the exact same mark as you, but if they're using it with unrelated goods and services, you still have the potential to protect that mark. So as you're thinking about kind of your clearance and the potential for infringement, there's two typical places where the issue of infringement may come into play. There's just use. So if I go out there and set up a website, I create my business, I start advertising my goods and services, it's possible that somebody who has a prior mark will just encounter that use in the marketplace and send me a letter saying, hey, this is my trademark, you need to stop using it immediately. And if you don't, all these bad things are going to happen. The other potential is if you file an application. So when you file an application, the Trademark Office is going to conduct an independent review of the USPTO database to see what other applications and registrations are in existence, and then they may refuse your application based off of what's already out there. And then after the Trademark Office completes that process, your application will be published for opposition. And at that point in time, if the Trademark Office hasn't rejected your mark, interested parties still have the option to say, hey, no, even though the Trademark Office didn't think this was confusingly similar, I think it's confusingly similar, so I'm going to object to the registration of your mark. And that's called an opposition. So I've included a number of slides here that can help you go about the process of trying to clear your trademark, trying to get additional information about what other rights are out there. I always think it's a good practice to kind of work with an attorney to help you through this process, but understand that sometimes that's not always an option. So, this kind of lays out the process for filing a trademark application, what the steps are that are involved and how the process goes. And then the next few slides are going to talk about how you can go about clearing that trademark. I think it's important to keep in mind kind of timing wise for trademarks. It's not a fast process, unfortunately. So if you file your application today, it's going to be 6 to 8 months before the Trademark Office even picks up the application for review. And, really the fastest you could expect to go from filing to a registration would be somewhere between, 1 to 2 years. But as we said earlier, it's important to remember that your rights in the trademark date back to the date that you filed your application. So even if it takes a long period of time, you've already started to protect your rights and are holding your place in line by filing that application. One thing that we haven't touched on is that it's possible to file an application even if you haven't started using the mark. So U.S. trademark law allows for filing either on the basis of use or on an intent to use. So if you're thinking about using a mark in connection with your business, and it's really important that you have protection for this mark even before you start marketing your goods and services, you can file an intent to use application for that mark. And that's going to hold your place in line for that mark even before you've started using it. And so the difference between an intent to use application and a use-based application is that they're both reviewed by the Trademark Office in the same way. They go through that process, they're both published for opposition, but a use-based application will then immediately proceed to registration if no oppositions are filed. For an intent to use application, you'll receive what's called a notice of allowance. And that notice of allowance starts at the time clock, essentially, in which you have to prove use of your mark or request an extension of time to do so. So those clocks are 6 months in length each time. And if you're not using it within 6 months after the notice of allowance, you can extend it. You can actually extend that deadline up to 5 times by paying the applicable fees to the Trademark Office. But if the mark is not in use within 3 years from the date of the notice of allowance, your application will go abandoned. So these screens here, I'm not going to particularly walk through here in the interest of time and get into some questions, but these will walk you through the process of doing a search on the Trademark Office so you can see whether or not your mark is available. It allows you to search by goods and services so you can see what other people are using their marks in connection with, and you can do that analysis to see if there's potential for infringement. In addition to searching the Trademark Office's database, it is important that you also do a common law search. As we talked about at the beginning, trademark rights in the United States arise based on use. So even if somebody hasn't filed an application to register their mark, it's possible that they have rights in the mark that are going to prevent you from using the mark. So it's important to do, basic internet searching, fire up Google, fire up Bing, whatever your preferred search engine is, and track down if somebody's using a similar mark. And I talked through here, there's some effective searching techniques through Google using their advanced search that can really help you kind of narrow down your search to see if somebody's using your mark or the mark that you're considering in connection with similar goods and services. All right, the last big bucket of IP protection is our trade secrets. Now, a trade secret is something that is protected by state law, so it varies somewhat between state to state, but is really anything that has value because it is not widely known kind of outside of your company or outside of you personally, and that you have taken steps to protect the confidentiality of that information. So there's a lot of different things that fall within trade secrets, and it sometimes can be used as a catch-all to do protection. But oftentimes I'll see trade secrets being used to protect the source code within software. So even though software is protected by copyright, a lot of times people will use trade secret as well to kind of rely on the fact that the source code is not known outside the company. Marketing lists, customer lists, financial information, pricing, all of this information, if it is not known outside of your company and you're taking active steps to protect it, is protected by trade secret. Now, some of the steps that you take to kind of protect it and maintain its confidentiality are, just your general business contracts. So having non-disclosure agreements, making sure you don't provide this information to others unless they've signed up to an NDA, having HR policies within your business that, prevent people from accessing information that they don't need to know or from using it in ways that are not associated with the business. Those are some of the examples of how you protect the trade secret in your business. So the important thing to keep in mind with regard to trade secrets is that trade secrets protect somebody from taking your information illegally and then using it as their own. So if somebody hacks into your computer systems, takes your customer list, and then starts, sending solicitations to your customers, that's going to be a misappropriation of trade secret. If an employee takes, all of your research and development and goes off to your competitor and provides that same information to your competitor, that's a misappropriation of trade secrets. That's something that you can prevent. What trade secrets doesn't prevent is independent creation. So whereas a patent gives you a monopoly to your invention, regardless of whether somebody independently creates it, trade secrets does not. So if I have created, the recipe for Coke and I've protected that as a trade secret, and all I've done is really kind of locked it up in a vault, not told anybody what the specific ingredients are, doesn't stop somebody else from going out and trying to recreate that same recipe and successfully doing so. If they've done that and they've done it independently without any information from me, I can't stop them from doing that in reliance on trade secret. So that's kind of one of the downfalls of trade secret protection. So the last thing I wanted to touch on today really relates to licensing. And this applies to all of the IP that we've talked about today. Once you have created something that is of value, whether it's a patented invention, whether it's software, whether it's the book that you've created, whatever it is, you need to find ways to commercialize that to make it into a successful business. And that often relates to how you license it to other people. So almost all of the rights that we've discussed today are something that can be licensed out, that you can grant other people the right to use, that you can get paid for. And so as you're thinking through that process, what you're going to be doing is licensing that information. So you have to be specific about what rights are you providing to the other person to do? What can they use it for? Are they limited in a geographic areas as far as where they can use it? How long do they get to use it? What do they have to pay you? Who owns any new rights associated with that IP? All of that can be spelled out within your licensing agreement and should be specifically considered and thought through. And for most of these things, you can parse the separate rights that are provided in as many different ways as you can get people to buy in on. So you can limit territories. If somebody has the right to distribute my copyright in North Carolina, but only in North Carolina, and somebody else has separate rights to it in New Mexico, you can kind of provide certain rights to one party and not to another. It's all something that can be worked out through the agreement, and it's something that allows you then to commercialize and kind of create value for the IP that you've created, even if it's not something that you're using directly within your business. So I know it was like, I apologize for that because I know it feels like drinking from a fire hose. It's just a lot of information, and there's a lot of kind of intricacies with all of those. So if you have specific questions that we don't cover in the question and answer period here, I've included my contact information on the slides, which I believe or hope that the slides are going to be made available to you. But feel free to reach out, contact me, and happy to answer the questions that you may have. I also just want to put a plug in too. If you want additional content about ways to protect your business, thinking about kind of startup issues and what that might look like, I encourage you to check out our podcast, the Founder Shares podcast. We have a lot of legal episodes where we cover topics like this, but we also have a lot of conversations with other business founders and their experience in starting their businesses. So I'd encourage you to check that out as well. But now I will open it up for questions and happy to answer any questions that people might have.
Thank you so much, Trevor. I'm going to be monitoring the Q&A session, but in the meantime, I just wanted to say thank you so much for all the information that you shared. Something that stuck out to me was the difference between the trade name and then also the trademark, the way you identify that. And it was so distinctive because for me, I've always seen Bojangles as chicken and biscuits, but knowing that is the trademark side, but then also the trade name, it was so very informative.
I appreciate that. And like we said, oftentimes there's overlap between all of these things that we've talked about. So sometimes it's used as a trade name, sometimes it's used as a trademark, but you really have to kind of, again, understand those differences to understand what rights you have and what you're protecting.
Absolutely. All right. Do we have any questions today? Just a moment. All right, so it doesn't look like we have any questions. So again, thank you, Trevor, for all the great information you shared today. It has truly been valuable. This webinar will be available within a week on our website at the ncbarfoundation.org. I would like to thank our program partners, Mount Biz Work in Asheville, Prospera and Climb in Charlotte, and the Small Business Hubs at Fayetteville State and East Carolina University. If you have any additional questions, please reach out to myself, to us at via email at foundation@ncbar.org. And then also, again, you can reach out to Trevor. And thank you all for joining today, and I hope you all have a great day.
Thank you.